Great. Good morning, everyone. It's so nice to be with you. It's lovely to be in our hometown of St. Louis at Union Station. I haven't been down here in a long time, so I hope everyone is enjoying the conference and the convention and getting to see the site. So I am Kate Nash from Two with Keeney, and I'm going to let Mary introduce herself.
Hi, I'm Mary Zabriskie. Good morning. When I submitted this presentation, I was working at St. Louis Community College, a proud Archer. I've since taken a position with Grand River Solutions, so now I am doing consulting work in the area of Title IX, student conduct, developing policy, and all kinds of fun things for schools across the country. So happy to be here.
All right. Mary, you want to go to our next slide, our first slide? So today we're going to be talking about, going just in the quick 45 minutes we have, kind of doing a high-level overview of the changes we expect to happen with the new Title IX regulations that just came out this year. We're going to kind of go through what we expect to change, again, at a high level, and what we expect not to change, because I know a lot of times we're just sort of overwhelmed by, here are all the things that are going to be different. So we're also going to be talking about what are the things that are going to be the same. And we got a few takeaways at the end, and we've left 5 minutes for questions. So if anyone has questions, we will try to get to those. All right. So just to give you all a quick, just an idea, we hear about the Title IX regulations a lot, and we wanted to put in context what is really happening in the process and what that means. So the Title IX is confusing because we've gotten over the years, for those of us who've been doing this for a long time, for a while, we were just getting what were called Dear Colleague letters, which were just what we call sub-regulatory guidance, letters from OCR telling us what we should and shouldn't do. And then in 2020, the Trump administration actually issued regulations, which have the force of law and have more specificity and requirements to them. So the process for issuing regulations is that the administration that wants to propose regulations has to actually publish what they want those regulations to be. They have to put them out for the public to look at them. They have to go through a public comment period. And then the administration that is going through this regulatory process has to actually read all of the comments that are submitted and respond to them in some way before they publish those final regulations. So in this situation, we all dealt with the new regulations that came out in August of 2020. And then, of course, more recently, we now have another set of regulations that just came out this year. So, Mary, if we want to go to the next slide. So the comment period for those regulations that we're talking about now actually closed on September 12th, 2022. Now, while there were only 60 days for the public to comment on the regulations, there is no time period that the administration has to have reviewed those and actually put out those final regulations. So while we only have 60 days to say what we like and don't like, they can take as much or as little time as they want to finalize the regulations. There is rampant speculation in the Title IX world about when those regulations will actually be published, but it's just that, speculation. Nobody knows for sure when that's actually going to happen. There are people who are speculating that the administration will try to have this pushed out in time for the next academic year, but again, it's speculation. And in large part, a lot of these things are driven by how many people do they have that can focus on this, who can work on it, who can review the regulations, the same things that you all deal with in your institutions when you're trying to get something done. There's man hours that are taken, and they only have so many of those. So we'll see when they come out. The regulations this time drew 240,000 comments, which is a lot. Like, this is like sort of a record-breaking number of comments. So that's a lot of comments to go through. A lot of those would have been auto-generated. You know, people set up templates, and they were kind of, you know, it's the same kind of thing over and over again, but they do have to go through all of those. So for the last regulations, it took about 15 months. This time, I don't know, again, it could be that long, it could be more, it could be less. We would just be speculating if we tried to guess. So that's kind of the process that we are in.
So the one thing I'll sort of comment as far as what Kate just said, and that is to keep in mind the last time when the new regulations came out, they came out in May, and we were given all the time of May till August to get our new rules in place, right, and to adopt those into our policies. So what Kate and I hope to do today is hit on some of those things that maybe you keep on your radar now as you're looking at your policies and thinking about what changes you might want to make at your school. I started with this sort of image of a pendulum, and I was going to talk about how under prior administrations, the policies were very complainant-oriented, were very sort of strongly in favor of individuals who were alleging that they'd been assaulted, that there were processes that were interpreted as being much more sort of weighted in favor of folks who were impacted by these kinds of cases, and how that sort of swung over. But I've got a better analogy, because thank you all, I had a chance to just spend some time really digging into these new proposed regulations, which is one of my all-time favorite things to do. And really the analogy that sort of rings more true to me is this idea of a box, okay? So under the 2020 regulations, we look at sort of the place where a case starts. We look at things like, who is going to be able to bring a case, what are the conditions under which they can bring a case, and what does that look like? And that box was really small, right? So the criteria for bringing a case, super high, right? Title IX, sexual harassment, severe, pervasive, objectively offensive, has to happen on your property or property you control, or at a program that you control, can't happen outside the United States. Really the idea, sort of that idea of a small box as far as who could bring a case, narrow that scope. But then when you come out of the small box and into the process is huge, right? It's live hearings, it's cross-examination, it's a formal complaint written and signed by the complainant. I mean, all of the criteria then for how the cases were going to work, super complicated. So, small box, big procedure, right? Well, now we're going to flip it. The new regulations really look to flip that model. So what we're looking at is a far more expansive view of who can bring cases and the circumstances under which cases can be brought. Bigger box to start with, way smaller process is what's being proposed. So the things that I'm going to touch on really are going to highlight those things, but that's a framework I'd encourage you to think about as far as what these changes might look like at your school and how you're going to manage those things. One thing that I'm reading in everything is that the responsibilities of your Title IX coordinator is going to grow, because we're going to have more cases, there'll be more responsibility for the kinds of things that they need to do. That work is expected to get the responsibilities of that job are expected to grow significantly. So that's exciting for all of us who do Title IX work. So anyway, so I'm going to skip my pendulum image, think boxes. And this is one of my most favorite new parts of the Title IX regulations, the proposed Title IX regulations. And they are particularly important to our students, right? Because we have lots of students who are non-traditionally aged, they're in different stages of their lives, they have kids, they have more kids, they're thinking of having kids. So pregnant and newly parenting students are a large population of students that we deal with. For a long time, there's been, 2013, there's been guidance from the Department of Education that has told us what the Department of Education says are the rights of pregnant students. These are rights that are dependent upon medical reasons for which someone who is pregnant, newly parenting, meaning somebody who has had a child, so it's again medical conditions related to childbirth. It could also be medical conditions related to a miscarriage, an abortion, or other kinds of medically related things to a pregnancy. And what the guidance told us was that those students would have, they could have excused absences. They couldn't be penalized for missing class. They have modification as far as their physical space. You can't ask pregnant people for notes if you're not asking students who were in a car accident and broke their elbow. If you're not asking the person in a cast for a note to say they can't come to class, you can't ask the pregnant person. So this guidance was provided to us. The new regulations for the first time adopt within the regulations. Again, that sort of, we move from the guidance piece, right, up to the regulations now say, You have got to provide support for pregnant students. You cannot discriminate against them. And it's really going to codify for us what this looks like, which I think will be really helpful because I think a lot of us struggle with, well, what does that mean, right? And we're getting some clues. I say that working with any sort of government agency, it's reading the tea leaves. It's putting together the pieces of things that they're saying. So very big that pregnant students are now pregnant, newly parenting. Now it's going to be officially in the new regulations. They're going to tell us what that looks like. They're telling us in the proposed regulations that it's going to be, we have a responsibility for publicizing, making known, educating people about what a pregnant or newly parenting student's rights are and being very forthcoming with that. But it's talking really about the rights of pregnant students, that it's going to be an individualized assessment as to the needs of the student, that it will be that what the student needs should be done unless it's a fundamental alteration of the class. So we're hearing this sort of individualized assessment, fundamental alteration. What are we thinking? ADA 504, right? So we've always sort of been like, well, being pregnant's not a disability, it's not the same thing. Well, Department of Education is talking about it like that's really the way they're seeing it. So much so that there was a case that came out within the last year about a community college in Salt Lake area where the school was found to have fallen short with their responsibilities in this area because they did not have a temporary disability policy. And Department of Education said, that the school really needed to have that because they were talking about pregnancy and being away from class as being sort of akin to a temporary disability. So this is kind of a new framework that we're hearing lots of pieces about, and it'll be interesting to see sort of what that looks like in the regulations. But this is an area that I'm really excited about because I know it impacts our students. We know that both from when this was announced, when they first started talking about it in 2013 and ever since, all kinds of research out there that talks about what an education can do for women and their families if they're able to complete, and sort of how much that matches up with the values and sort of our mission statements and commitment for for those of us that sort of committed our professional lives to working in a community college setting. So I'm excited about that. So pregnant students are there, and again, drum roll please, for the first time in the regulations, the rights of LGBT students have been called out. So again, we're not looking at the Supreme Court guidance that came out from Bostock. It sort of adopts that. And so now we have a couple of our student populations for whom Title IX clearly applies in the regulations, and we're going to get some guidance about what that looks like, with the caveat that things like bathrooms, locker rooms, sports teams, the Department of Education was really brave on these questions that lots of folks are sort of demanding answers on, and said, we'll get back to you on that. So that is on hold, and we're not going to hear that'll come, if it comes, at a later date.
Mary, just a couple things on the pregnant students. So, well, first of all, on the LGBTQ, they wanted to release the regulations on the 50th anniversary of Title IX, and so they did that. So they didn't have enough time because they knew that the other stuff would take longer. So this was all about timing and presentation
yes.
as these things go.
Yes.
But on the pregnant students, I just want to mention a few things that will be real practical tips that you all need to be aware of. One, you will need to let pregnant students know to go to Title IX. So the issue here is that they're telling us in the proposed regulations that in the same way that we have mandatory reporters under Title IX for sexual assault issues, here if an individual knows from a student that they are pregnant and they don't otherwise have reason to believe that the pregnant student knows to go to Title IX, they will need to tell them to go to Title IX to get those supportive measures that they'll be entitled to. So that's one thing. One thing that has always bothered me about this nomenclature is this question of new parenting, and because it's really confusing about what that means. And Mary is exactly right that this really relates to a medical condition, right? So it really relates to women who have given birth. And I think the parenting language is confusing because, for example, if you were to give leave beyond leave for medical reasons to a female student because they wanted additional bonding time, not giving that to male students would actually be a violation of Title IX because you're treating men and women differently based on sex. So this parenting language in the regulations is really talking, as Mary said, about the medical conditions that are created by pregnancy that impact women who have given birth. And so just be thinking about that as you're thinking about what does it mean to have parenting students, because parenting, of course, you'll have lots of students who parent, but you have male students who parent, you have female students who parent, you have all kinds of students who parent. So that's some language that I think is a little bit confusing. And then one other, just another kind of quick tip on this is that we have had for many years after the changes to the FLSA regulations, the need, under the ACA, the need to provide lactation rooms to our employees. Now we will need to provide lactation space to students, which I think many institutions already do, but now it's going to be formalized. You're going to have to provide those lactation spaces to your students, and they cannot be bathrooms. So there are some real, as the regulations get finalized, some real checkbox kind of things you're going to have to be thinking about when it comes to pregnant and parenting students. And again, I think that parenting gets a little bit confusing, but if you keep it in the framework of medical condition, that's an easier way to think about it.
The regulations even go so far as to talk about pregnancy or perceived pregnancy. So the idea is you can't discriminate against someone if you think they're pregnant and they're not. So not only are they going in, they're going all in, and it'll be interesting to see when the new regulations come out what that looks like. So this is one of those areas where we talk about big box, smaller process, right? Because what we're looking at now is the ability for the decision maker, the person who decides whether or not there's been a violation of Title IX, who that can be and what that process can look like. Under the current regulations, it's got to be a live hearing. You've got to have folks subject to cross-examination conducted by an advisor. It's got to be recorded. It's a lot of process. Under the new proposed regulations, they're talking about sort of what it is that a decision maker needs to be thinking about and a framework for thinking about it. So assessing the credibility, you've got to have a process through which the decision maker is assessing credibility, and that's got to be spelled out. They are basing a credibility on consistency of statements, on what witnesses say. You know, are all the witnesses supporting one version versus another? You've got to articulate what those are, but then who decides? We've got a lot of leeway on that. So much so that they're talking about this bringing back the one investigator model, that you could now have someone who does an investigation, assesses the credibility using the criteria you've set up, and then makes the decision on behalf of the institution. You can also have a hearing, right? So there's now this wide spectrum of what your process could look like, and more discretion being given to the schools to set that up. So I would encourage everybody to be thinking about who's on the bench at your school, who's going to be sort of taking on these responsibilities. You may have cultivated a whole community of folks because you had to have hearing officers and advisors, so you may have a wealth of people who are ready to sort of to be helpful with this, but thinking about what that process might look like for your school, I think is really important. They're talking about the sort of one investigator model as being an option, and I know that was popular before the new regulations. I would just caution you that having one person sort of doing it all, it's difficult. It's difficult then when those decisions are questioned, and we know they will be questioned no matter who makes the decision, right? I think it can be more difficult to sort of say it's this one person, they do everything, and we're 100%, that's it. I think another level of review can be helpful. So an investigator, sort of the model where an investigator investigates, writes the report, it's a factual report, your fact finder talks to the involved parties, has the ability to assess credibility, et cetera, and makes that decision. Or a panel of a few people gives you a little more room to sort of say, we had multiple people who are well trained. The new regulations talk about all employees needing to be trained on Title IX, and then specific training for folks who are involved in the process. So, you know, you'd want the ability to say, we got good people, well trained, they're doing this work. There were levels of review. I think there's something to be said for that. But, there's also the efficiency of one person doing it all. And if it's the right person who can write that report very well, gather all that information, it could work. But you need to think about what's going to work for your institution, like now.
Mary, I'm just going to jump in on that. This is actually on a later slide too, but I think it really goes well with what you just said. There is this temptation, I feel the temptation, to go to the single investigator model because it requires less people to be involved. But if you go to that model, the proposed regulations are very clear that you still have to have what is essentially cross-examination that is then performed by that sole investigator. So that means you still have to allow both parties to propose questions to be asked to the other one. They still have to ask those questions. So that means that the single investigator is going to have multiple meetings over and over again with the parties. And I've talked to some institutions who are like, you know what, a hearing is just more efficient. We just get it all done at one time. So there are efficiencies to a hearing. While a hearing feels very formal, there are going to be some efficiencies that are built in. So I would totally encourage you in the same way Mary has, and just highlight what Mary has said, that you really have to think about what has been working at your institution and what is going to work for you in the future. It is going to be very tempting to just fall back into that single investigator model, but it is not it's not the same single investigator model that we had before the regulations changed in 2020. It's a much more in-depth kind of single investigator model.
Yes, yep. And when we look at the procedures, right now, I think under the current regulations, we think about what's Title IX sexual harassment versus conduct versus, all of these definitions and all of these different tracks of things. The proposed new regulations really help us out in giving us sort of a universal set of expectations around our procedures that goes for most situations. There's more talk about employees and employee rights under Title IX, so we're going to think about some clarity around that. We know that there are expectations regarding not discriminating based on sex with employees under Title VII and other guidance. But what we're looking at is the Title IX regulations are talking a lot more about employees. And so this universal set of procedures that goes for all claims of sex-based discrimination. I'm not getting the same salary, I didn't get the right grade because I'm a woman or I'm a trans person, right? So discrimination, straight up discrimination, those universal policies cover all of those cases regardless of whether it's an employee or a student. It also covers all employee cases. So regardless if it's sexual harassment, for employees, those sort of universal procedures. And when I'm talking procedures, I'm talking about what's got to be in your notice of there being a claim against you. What's got to be some of the basic practice within your procedure, et cetera. So within those universal procedures, all claims by employees come under those universal procedures. When we talk about students who are alleging sexual harassment, which is, I forget the new definition that they're proposing, it's not severe, pervasive, and objectively offensive. Are we back to the or? Yeah. So instead of severe, pervasive, and objectively offensive, which is what we need now for sexual harassment, it's severe, pervasive, or. So you just need one, right? When we're talking, and that also for sexual harassment, we're talking about relationship violence, stalking, sexual assault, et cetera. When we move into that realm and it's a claim of sexual harassment sexual harassment involving a student, whether they're complainant or respondent, you get all the universal procedures plus some stuff, right? So a little more process. Again, not to where we are now, but I think it's interesting that we have sort of these universal processes more for students involved in these cases, which I think is something that's arguable, being sort of that's who we're here to serve and support. And really thinking about, as you're looking at your Title IX policies in contemplation of this, I would challenge you, and it could be a lot, but it's also an opportunity to think about your other discrimination policies, right? Because we had our other claims, our ADA 504 claims, race claims, discrimination based on religion claims. Those are separate processes because Title IX just got so different, right? So you had to kind of have these multiple processes going on. I think if we look at sort of these core procedures that are being proposed, and maybe a sprinkling of some of those core plus procedures, there could be some ways to sort of pull some of your procedures all and making them more consistent with this model, because it's a really intentional due process, decision-making kinds of things that could serve you well on multiple fronts. So if you're looking at those policies at this time, encourage you to kind of just throw those papers up in the air and think about how there may be some ways to simplify things as you're looking at this. And if you've got to go through your review process anyway, I'm a big believer for just bringing it all on.
You got the clicker.
Oh, sorry. What did I forget? Oh, jurisdictional expansion. This is easy. International stuff, which was off the table, it's back. If it's your program and it's overseas, an allegation of sexual discrimination or harassment, that comes back. Bigger box, right? So those cases, those folks can bring complaints in those situations. Also, the idea of if something happens off campus in a building you don't own or control, not part of a student organization that is part of your institution, but something happens, especially as it relates to students, and that brings some negative impact, it disrupts your campus in some way. Again, we're making that box bigger and expanding. Those cases can be considered now under the new regulations. Sure, I think if there were students who lived in an apartment building down the street from campus, independently owned, there's an allegation of a sexual assault, and the student who was sexually assaulted alleged by another student or an employee it was a violent assault, the person was arrested, that person's now back on your campus, and whether or not you're always gonna provide, even if there's not an obligation to adjudicate responsibility in that case, you're going to absolutely provide supportive measures to the complainant student. But you could say that that student, because of what occurred, potentially poses a threat, and we're going to have some accountability measures for that student on our campus because there are concerns that there is a threat or disruption, or they're part of an athletic team, or there's something. You're going to set your criteria for what that looks like at your school. But this is the way we oftentimes think about our conduct cases, right? That it could be conduct that some schools would say their conduct of students off campus. If it negatively impacts the campus community, we're going to have our conduct process cover that. And what's interesting with the regulations, the proposed regulations, is they're saying that if you do that, if you do that with you can do that here, but really it should be in line with whatever your process is for your conduct cases. Because the idea is if we're sort of going to expand that, open up the box, Department of Education is saying, then that should be consistent for schools between their conduct process and their Title IX process. So it was, the 2020 regulations made this work easier in some ways because it was, just, yes, if it's here, yes, if it's there, no, and whatever. That's easier. What's exciting about these regulations is it gives us some more space to have conversations and think about what is it that we're trying to do with our policies? What is it that we're trying to do when folks are struggling with these issues? And how this sort of trauma that can come from these kinds of cases can be hugely impactful to a student's experience. I don't know how many of you have worked with a student who's experienced a situation with a relationship violence or a sexual assault when they're in school, and they stick around for a little while and then they're gone. And folks like Shannon from St. Louis Community College and her team will call endlessly trying to get that student back. What do you need? How can we help you? What resources can we provide? We've got faculty who are willing to work. I'll take your work late. I know you had this horrible thing. Let me work with you, but those students just can't do it. It's just too hard. And so I think these new proposed regulations give us more space to think about the difficult conversations of the accountability piece, right? We think about somebody being accountable for their actions, but also sort of what the commitment to our students who are negatively impacted by these situations, sort of what we can do in a process that is fair and equitable to everyone, but that we hopefully have some space to be able to do more. Okay, this is my last slide, I think. So the other process issues, again, the complaint, we talked about how the complaint under the current regulations, written, signed, submitted by the complainant, it's very formalized. If they don't write it and they don't sign it, we cannot pursue it under Title IX sexual harassment policies, except for very, very limited circumstances where there's an imminent threat of ongoing harm, and then the Title IX coordinator does it, and so it's been a process where we've really narrowed that scope based on complaints. Now it's if a student comes and tells us, this is what my experience was and I want to file a complaint and I'm complaining to you right now, that's enough, okay? So expanding the box and who can come in. Accessibility, again, tea leaves here, right? The regulations, we've always had guidance which has said when we have these procedural undertakings, we need to be aware that people experience life differently depending upon who they are and the strengths and weaknesses they bring to their life experience, or the challenges they may have in their life experience. So we would never tell a student who's blind in a Title IX case, you know, here's your 500 pages of document that I just printed out on the printer today, without understanding that that's not helpful, right? For the process to be equitable, we need to have those dictated somewhere or in a format that that student could read. We also know students have anxiety and challenges that make it difficult. If a student has anxiety and says this is going to be really hard for me, we may want to have sessions for that hearing that are over multiple days or that we take frequent breaks, right? So we want to be looking at our process to make sure it's inclusive for folks with disability. For K through 12, they've given really clear guidance in the proposed regulations that say if the students who are involved in a Title IX case, K through 12, if they're a student with a disability, then you must consult with the IEP team to get information about how to make that process accessible for them. They don't reach to that degree when it comes to post-secondary, but they do say that schools may and consult with your disability resource folks on that. So I think if you know that a student has accommodations in their classes, I'd want to have a conversation with that student or an employee who's getting accommodations in the workplace. If they've shared that with you, tell me how that might work for you in this setting. You've explained what your process is, so when you hear that, what are the ways in which this might be challenging for you, or it might be more helpful for you to experience the next several months in this arena? And so I think they're giving us some clues that these are things to think about, and these are areas where when we look at the cases Department of Education is looking at and where discrimination is alleged in higher education, students with disabilities and bringing complaints under the ADA 504 eclipses every other type of complaint out there. So you should be looking for those elements in your cases, and what I recommend that you do is make sure you put in your policy and you put in your notice letters every single time you're going to put a statement that that retaliation is forbidden, not accepted. Reminder, every time, every piece of paper that goes out, every email, you're going to have a few sentences on no retaliation, and you should have sentences that say, and if you're a student with a disability or an employee with a disability and believe that you need accommodations during this process, please let us know. Right? Because it's not like K through 12 where we've got to go ask the IEP office, hey, Mary Zabriskie, what does she have disability? And they're going to share that. We're not obligated to do that, and this information isn't something that you would have access to without the student's permission. So you just want to make it very clear that if that's an issue, they should let you know, and you'll have that conversation.
All right. Okay, so I promised our moderator that we're going to stay on time, so I'm going to stay at a high level here. So I have to say, I really appreciate listening to Mary talk about this because she's talking about all this as opportunities, and as an attorney who does defense work and represents institutions, I often find myself really frustrated and annoyed by all the regulations because I'm like, why are people in higher education? It is not to hurt students, it is to help students and to educate them. And they are coming with grace and good intention. Let them do their jobs. And so I have to remind myself these are opportunities because I often find them to be annoyances. So I'll just say that.
And I just think people want to do the right thing.
Right.
And it's so hard to know what that is sometimes. And so, you know, that's kind of, when we have an opportunity for process to match values and things, I think that can be helpful.
No, that is true. So I always like to think about, the pendulum, why I really appreciate the box analogy. The pendulum analogy always speaks to me because this is a very political issue. And it swings depending on the administration that is in power, and it will swing again if there's a change in the election. And so I always try to stick with the fundamentals. What are the fundamentals that will not change so that you don't feel like you're constantly scampering, running to like catch up with the next thing and figure out what to do? So I always focus on what is it we have to do regardless of who's writing the regulations. And one of those things is we have to treat students equitably, right? We have to treat them equitably regardless of whether they are a complainant or a respondent. I will never forget a call I got before all of this happened. This was like a precursor when I was a much younger attorney. I got a call from a dean of students saying, I've had a woman come in, she's crying, she says she's been sexually assaulted. I want to get this guy off campus. I want to get him off campus now, I want to expel him. And I said, wait a minute, I understand, I hear what you're saying, I appreciate that protective instinct. However, he is also your student. He also has rights under your process. We don't know what happened. You've only heard from her. You have to slow this down. You have to take care of her, and you also have to take care of him because they're both your students, both part of your community. That has not changed. When we talked about that pendulum swinging, 2011, it swung way over, and we were kind of told push those respondents off campus, swings back 2020, says no, they've been treated badly. And now we're I feel like we're regulating a little bit. We're not getting that big swing we got before. But that, regardless of what regulations say, regardless of who's in power, we have to treat everyone fairly, and we have to remember they are our students. And that is still written, that is written into the language of these regulations, that you have to treat complainants and respondents equitably, regardless of their situation. Another thing that I think has been helpful about these regulations that doesn't really change, but it is more explicit, is those supportive measures. There is more discussion about how you offer supportive measures. And one of the big things that has always been in tension, and still is in tension in the proposed regulations, is what do you do in a situation where there has not yet been adjudication, and you have a student who's a complainant coming in and saying, I don't want to be in class with that respondent anymore. You need to pull that person out. It is not fair that I should have to be pulled out when I went through this. I think those are really difficult situations to navigate, and you feel like someone is going to carry a burden here, right? Someone is going to feel like they are being treated unfairly, and you don't know who has actually been a victim or not. And the regulations, they actually give a little more leeway and say that you can kind of burden the respondent a little bit as long as it's only for the duration of the grievance process. I will tell you, though, I would suggest that you really think carefully about that. And I think that following the equitable treatment of the parties throughout the process is always the best way to go. Because that regulation about burdening, that could change again. That is totally a political issue, right? And so really having a thoughtful process about how are we making this decision. So for example, I know that this student, there's another section of this course that this person could go to that isn't gonna conflict with anything else in their schedule. Regardless of whether it's the respondent or the complainant, that's probably the fair thing to do, right? Like try to figure out how to work through that process with them. And the other thing that hasn't changed in the regulations is this requirement for due process. And I'm really gonna hit on this very strongly. We talked about this earlier, but there is going to be a temptation, and it may be the right thing for your institution to move back to that single investigator model. However, if you do that, the regulations are still going to require that the information that is relied on by the decision maker have gone through some rigorous testing, meaning gone back and forth. You've given people a chance to really question it. And that's going to be really difficult to do in the single investigator model. And so as you're thinking about how are we going to provide due process and access to process to these individuals, I would actually think about giving yourself some options. I know many institutions, I know we did this with policies that we revised, essentially had a process for what is currently considered Title IX type issues, that smaller box Mary talked about, and then processes for everything else. And you're going to have the flexibility to have options to say, and you're going to have the flexibility to say that you as the institution get to decide what option to follow in a given circumstance. And I think that it makes sense to have options, and something that the regulations haven't changed but have expanded on and talked more about is the ability to do informal resolution, which is so key, right? Not every Title IX issue that walks into your office needs a live hearing. That's crazy. It's a crazy use of resources, and it is not restorative for the students who are coming to complain. And so the regulations are going to allow you to have, talk more about processes where you can informally resolve these situations and not have to put everyone through these lengthy processes, which can be so hard on folks. So those are things that won't change. And then, whoops, gonna go to the next.
And I just wanted to say with the informal resolution, under the current regulations, there's got to be a formal complaint filed before informal resolution can be considered. The new regulations are proposing informal resolution pretty much anytime, anywhere. It gives you some assessments of when it would be appropriate and when it might not be appropriate, but there's more places where you could have those conversations with students and offer that as an option.
Yeah, and I think, and the informal resolution thing, I think the fear that OCR has had about informal resolution is it will be a way to either railroad respondents and get them to agree to things they wouldn't otherwise agree to, or it'll be something that will be used against complainants and sort of take away their ability to have access to process. And so if you do informal resolution, the PROS regulations would require that you have pretty much a written, they have to understand what the consequences of going through this are, which I think is actually a really great change. So other things that won't change, this was kind of controversial in 2020, and now it sort of seems to have settled out, but the idea that you have to have in your policy, and you have to have in the notices that go out to the folks, a presumption that a respondent is not responsible. And that felt kind of weird in 2020. It felt sort of like it was such a shift from where we had been previously. But now it's kind of like, well, yeah, they aren't responsible until they're found responsible through a process. And so that's still in the regulations and still a requirement to be in your policies and in your notices. Now, this information that can be used for making determinations, this is that piece. We've talked about it over and over again, and we keep talking about it because it is so important to think about as you're considering what your process is going to look like in the future. And that, again, this is not changing to a situation like we had prior to 2020 where an investigator can go interview someone once, interview the other person once, and make a decision. The information that you're relying on to make your determinations has to be reliable and tested if it is related to issues that deal with different versions of what happened. Now, if you're making a determination where you have video or you have other witnesses and it's not really contested, then that's one thing. But a lot of these situations become about two people in a room where they have conflicting, they're telling you two different stories. And the regulations are still going to require that you really test those two different versions by kind of going back and forth, giving each the opportunity to propose questions to be asked of the other. So it's not as clear-cut as we thought of before when it was a single investigator model. So I just want to make clear that information has to be reliable and has to be tested, especially in situations where it involves people that are telling you two different things happened at the same time. And finally, something that won't change is this idea that the onus is on the institution. Now, this is, again, something that if you're newer to this, it seems like, well, yeah, of course the onus is on the institution. but I've done this long enough, and Mary's done this long enough, that we're used to, and many of you have done this long enough, that there is this model of student discipline from years ago, and these models shift over time, where essentially students were making the cases, right? Like if you had, like this idea that someone has to bring a complaint against another student, oftentimes also required that the students bring the information that would be used by the institution to adjudicate whether or not there had been a violation of your policies. The regulations have changed that and said, no, the students can initiate a complaint, but institution, you are responsible for figuring out what happened and for getting the information to determine what happened. This puts institutions wearing a lot of different hats, right? So you are the investigators, you are the decision makers, you are the appeal officers. All of that is happening under the big tent of the institution itself. And so you have to think about, how do you do that? Who does that? How do you assign it in a way that's fair, creates the checks and balances you need to make sure that it's done appropriately? But the bottom line is that the onus remains on your institution to gather the information. While students can contribute to that, it is your responsibility, not the student's responsibility. All right. And the other thing that won't change, and I know we're at our time, is that you have to remain free from bias and conflict of interest. And this is not anything new, but it just bears repeating that the concerns come up, and I litigate these cases, and the issues that come up are people saying things like, well, that Title IX coordinator said, well, that she always believes women, which is really hard when we came after the Believe Her movements and all of these movements. It's really hard because you have to have people who are both credible to your community, but also are perceived as being free of bias and are going to treat anyone who walks in the room as being a student who needs to be treated fairly and given access to process. That has not changed. So that is something, again, that all of you do, and I think that all of you will continue to do, but is written directly into the regulations. All right, so we are at our time, but I think we've hit on a lot of these already, Mary, but do you want to hit any other final points?
No, just, as you're thinking about your policy, and I expect those of you that do this work are thinking, what do you have? What's going to change? What does that look like? I would say we've hit on some things that we know are coming. So if the degree to which you can get ready for those, get ready for it. And I think that this is going to be an exciting time to look critically at this work and the opportunity that we have to do it better.
Thank you all. We do, if anyone has questions, I know we're at our time and you've got to go to your next sessions, but we're happy to stick around and answer questions if anyone has any. Oh, okay. There's a break. Well, then, all the questions.
Yeah.
Yeah, that's so amazing.
Can you explain what it is you're doing?
This is, I call it live illustration. I'm just taking notes from what you guys are talking about today. So hopefully I'm catching most things, at least good enough for you to take a photo and remember it a little bit better as you bring it back to your schools. I'll be in this room and next room over the course of the day.
Very cool.
Yes, Chancellor Ross.
No, trustee.
Trustee.
I'd love to be chancellor, but I don't understand how you would figure out who doesn't have any bias, because I think that's a fool's errand to figure out. Now, there are people who are obviously full of bias, but it's pretty hard to know that someone doesn't
Yeah.
own some bias.
Let me speak to that for a minute. And let me give some historical context here. So in 2019, the Missouri General Assembly had proposed legislation that would have required that anyone who does Title IX type work actually fill out an affidavit that had to include information like, I've been sexually assaulted, or I know someone who's been sexually assaulted, or whatever, because they wanted to have some type of documentation that people could look at to determine if someone might have bias, which is so invasive and just over the top, right? And so we talk about these terms of bias, and most of the time in most real world situations, bias is really going to exist in situations where you have someone who does conduct work and Title IX work and has adjudicated a conduct case against a student, so has prior knowledge of the student's behaviors, and then might be perceived as having information that could bias them in the process because they know something about that student. Bias, we cannot know what's in people's minds, right? And so when there is litigation about Title IX, people will point to comments like, in this process, the adjudicator said something like, well, women lie. and so, things like that. And so they are these things where people have said something that then become an indicia of bias. But we often hear students or others in processes point to and say, I don't want that decision maker, I don't want that investigator because I believe they're biased. We would then say to the student or the individual, what makes you think that? Do you have a prior relationship with them? Do you know them? Do you believe they have a relationship with the other party? And like I've had situations where a student believed that the respondent and the decision maker had a mentor-mentee relationship. That would be a bias situation. But it's the word bias is one of those words that is overutilized, right? It means different things to different people. So in this context, it really has to mean something where either you have some knowledge or some relationship to one of the individuals that makes it difficult for you to separate out, or gives the appearance of making it difficult. But of course, we're not expecting that anyone who does this work is going to sign an affidavit saying, whatever it is, because we all have different beliefs about what bias even is, right? So how are we ever going to run that to ground? But that's a great question because bias is a really hard thing to work through.
And so what you can do to get to those things, right, is if you have a panel of decision makers or you have folks who are involved, it's sort of, they get a letter and it says, we've got a case. It involves these people. We don't say what their roles are. It could be a witness. It could be an advisor. It could be, anyone, right? It's these people. And it's generally it's a sexual assault that happened on campus. Give them some general information, right? With the idea being that if you've been trained, as you should be in the process, and you're a person who's involved in the process, you're going to take a minute and think, are there biases or knowledge that I have that impacts my ability to be fair? Some people will say if it involves kids, I can't, really young people, women in their first semester at college, traditionally, like if it happens in that building, I had an experience, I just can't be on it, right? And so we want to challenge people to sort of think about how these kinds of experiences or biases they may have, recognizing we all have some, how those may impact our ability to be fair. Because I'll share with you that I've worked with students, and in a prior life as a criminal defense attorney, I've worked with people who, in my heart of hearts, loved many of them, couldn't stand others of them. And the question is there something there that's bias or makes it so that I cannot do my job and do fairly and provide them with what I've committed to providing them, either as an individual or an institution? And those are things I need to be asking myself over and over and over again. And if that happens, you need to step back and somebody else can step in and take that over. So it's a place to have those conversations as well, which I think is an opportunity, again, that we don't get very often.
Love that optimism. Love it. Yeah. Any other questions? Yeah. Jeff?
Yeah.
Mine's on the pregnancy and students being out with temporary disability independently. So if they're out for longer than 2 weeks, our financial aid process will be drop them from their class for not attending for our students' training. But for Title IX, you might let them out for longer than 2 weeks. So how would you guys recommend addressing that? Because I often find out about it after they've already done.
I would talk to your financial aid people to see what that looks like. One thing that we started to do more of when I was at St. Louis Community College was give students incompletes, and sort of that idea that they're still in that class. They're still eligible for those credits. They've not dropped it. It's just a period of time, and there's ongoing conversations with the professor about what needs to happen and when, and communication, and sort of looking for those things that give you what you need, but don't impact financial aid or other kinds of financial things that and again, sometimes if folks are on probation or parole, being in school is important. So thinking about those ways, that's a great question, that some of the things that we work on here unintentionally negatively impact the student. So really be thinking about those. And I would be asking the student that as well. We need to make sure financial aid is aware. I don't know what kind of financial aid you have. This typically works, but there may be programs I'm not aware of. And also, is there anything else in your life where being in school is required in some way for housing or something, a benefit of some kind? But again, I think if you can look at sort of that idea of being an incomplete, you're still in that class. And it means that the student doesn't have to re-enroll, re-register, whatever. It creates more work for deans and department chairs because we don't always have the same faculty coming back. But I think administratively, those tasks are a lot easier than responding to a lawsuit. So.
It's just you can't assume that all these departments work together to figure
Right.
out things to where that work. They don't. And so I agree with everything Mary said. I think you just have to work through it. And it depends on the length of time the person's out and all of those types of things. There's no easy answer, unfortunately. Yeah. Jeff, did you have a question?
Yeah, so facilities and new regulations. Do you think the local codes and architecture have been aware of all this?
I think we want to be concerned about it because I don't think it's going to be sort of a carte blanche. I mean, we're going to have to make sure that there's lactation rooms, and I know at St. Louis Community College, we have lactation spaces on all the campuses that comply with what is required. The challenge is that the way it's set up now, it's available as needed. So it's not that, so you've got to know to ask somebody to get the key to open the space, right? Which means it's secure and it'll stay clean, but it means they need to know how to ask. So I think the new regulations really tell us we can't wait for hope that somebody knows to ask. We have to be way more proactive to either say, it's this space, it's always this space, this is how you can get into it, but thinking about that. But that's a room, that's not a bathroom, basically, and so you can be okay with what that looks like. I think when we're talking about a pregnant student, think about some of the classrooms where the chairs are attached to the desk, right? If those are the only chairs in that room, or it's a chair that's affixed to the table, like a theater type seating, and you've got to pull up or pull a thing over, if you're pregnant or even just sort of have gained some weight, those chairs are not accessible. So it's that idea that if you are a student who is pregnant and you need something, you need to be able to use the elevator. And you need to know where that is. And if it's a service elevator, because we don't have an elevator in that building, that, thinking about those things, it's more about an accessibility perspective, similar to what we have now, that our codes don't provide that every space is as accessible as it might need to be for every condition that any student may have, but it does say if they ask and it's reasonable, we need to provide it. And the fact that it's costly is usually 99.999% of the time not an excuse that holds water with the Department of Education, because when we say we can't afford to provide, and I know that wouldn't happen at St. Louis Community College, but for those schools that do say things like that, then what Department of Education does when the student then files a complaint is they say, we're going to look at your budget, and look, you spent how much money for your marketing materials, you spent how much money for a new office for a high-level administrator, but you can't get the pregnant gal a desk she can sit in, or the disabled student something that they need. So we just want to think about sort of if a student needs it, how do we get it? And in our systems where purchasing things and picking things out, those things take time, we need to think about the fact that our class schedules move at such a quick pace that if it takes us 3 weeks to figure out how to get them a chair and they've not been able to sit comfortably for 3 weeks and it's an 8-week class, that's a lot. So we need to be not only responsive, but as agile as we can be as institutions to meet those needs. And that's why when we think about building new spaces and we think about universal design, making sure that there are chairs that people who are larger by nature or larger by pregnancy situations can fit in, just making sure there's enough of those kinds of chairs in spaces. So you wouldn't even have to think about making it available for one person because you just have seating that works for lots of people with lots of sizes and maybe potential limitations. The same thing with sort of roll-up computers and other kinds of things that folks, a standing computer station, again, if you're pregnant, I can't stand, I need to sit, right? And thinking about how we provide those things.
It's really about connecting your Title IX folks and your disability folks so they have access to the same resources so that they can make those quick adjustments that are needed. Because you already have infrastructure for this, or you should. And so it's really just about making those connections.
And we've teamed up with our access offices on campus so that those kinds of things are turned around quite quickly most of the time.
Yeah, and again, just to go back to what hasn't changed, none of that is new, right? You've had these issues with disability issues you've already had. It's a question now that Title IX needs access to those as well, but you should have infrastructure in place that exists that you can access for this purpose. So I always am trying to be like, it's not like we're not having to like write a new chapter here. So, all right, any other questions? All right, well, thank you all. Now I feel like we are going to keep you from your next session. So, so we'll, thanks everyone.
Thanks, everybody.